Hello everyone, my name is Giovanni Nogales and I'm a paralegal here at Laos Parker. Welcome to today's webinar hosted by the Texas Association for Home Care and Hospice. Today's webinar is entitled The False Claims Act and Its Impact on Home Health and Hospice Agencies. Today's presenters are Lester Johnson and Ashley Morgan. Unfortunately, Lester has a family emergency, so he will be attending, so Ashley will be the one conducting this presentation. Ashley Morgan is a partner at Laos Parker's DC office. Ashley focuses her practice on regulatory healthcare compliance matters, fraud and abuse, and reimbursement issues. Ms. Morgan represents healthcare providers across the country in connections with a wide variety of health law issues, including coverage disputes, documentation concerns, compliance, medical board complaints, and exclusion termination issues. She has worked with an assortment of providers, including home health companies and hospice agencies. Ms. Morgan is also a certified professional coder, a certified medical reimbursement specialist, and a certified medical compliance officer. This is just a quick reminder. If you have any questions throughout the presentation, please feel free to type them in the chat box, and we'll address as many as possible at the end of the presentation. So without further ado, I present to you speakers, Ashley Morgan.
Thank you, Gio, and thank you all for being here today. I'm sorry that you're going to have to listen to me for a full hour and don't get to hear Lester, but unfortunately, that's what's happening today. So today we're going to be talking about the False Claims Act and specifically its impact on home health and hospice agencies. So let's go ahead and go to the next slide. Thank you, Gio. Just a brief disclaimer before we get started. This outline is being provided as general information only. This is educational today. It does not constitute legal advice and should not be used as a substitute for seeking your own legal counsel. While I am an attorney, I am not your attorney specifically, and outcomes in cases vary depending on the specific facts of each case. So you should reach out to your specific healthcare attorney for resolutions on your specific cases. Okay, so an overview of what we're going to talk about today. We're going to go through current federal investigation and enforcement efforts, talk about some cases against home health and hospice agencies, their owners and staff. We're going to go through some sources of audits and fraud investigations. Where do these cases originate from? I'm going to take you through a legal overview and some common statutes that are cited in FCA cases. We're going to talk about the anti-kickback statute during that discussion, and then we're going to talk about problems that are identified in recent cases that are not related to the anti-kickback statute, because a lot of FCA cases do result from kickback violations, but not all. And then we're going to just go through some final thoughts and tips at the end. Okay, so at the outset, I want to just give an overview of the various strike forces that are actively working to prevent and combat healthcare fraud. These strike forces represent a partnership between the criminal division, the U.S. attorney's offices throughout the country, the FBI, the HHS, OIG, and the DEA. So there are different areas and jurisdictions where these strike forces are located and are reviewing action. For today, for Texas, you see that there's a strike force specifically in Texas that is focused on Houston, Dallas, and San Antonio. So that's where that strike force is specifically looking and targeting their cases. That does not mean that the remainder of the state is free from review or jurisdiction, but there is additional efforts, additional funding, additional eyes being put on home health providers and hospice providers in the Houston, Dallas, and San Antonio areas. Major metropolitan areas make sense, lots of providers. We're going to get some extra resources there, but those of you that are in the rest of the state, they also are doing investigations throughout the state as well. But you see that there are areas that, have always been of interest. For example, in Florida, we've got Miami up there. That's always been a hot area for fraud investigation. In New York, we have Brooklyn, New Jersey, and Pennsylvania. We have Newark and Philadelphia. They're areas where the government has commonly utilized its resources to do some extra enforcement action. And they are all specialized in typically major metropolitan areas. So this is a slide that talks about the 2025 National Healthcare Fraud Takedown. The government likes to release information on its enforcement efforts and how it's really going after providers, recouping money back from people who are committing fraud on the government. This is as of today. So the National Fraud Healthcare Takedown this year so far has done $14.6 billion in intended fraud loss charged. They've charged individuals or companies with that much fraud, $14.6 billion. Of that $14.6 billion, we see some additional information up here. So there has been 15.6 million that is related to pills of controlled substances that were illegally distributed. This has been a hot area if you listen to, conversations with the president or with other political individuals. There's a lot of conversation about controlled substances, those being distributed throughout the country. So $15.6 million of that intended fraud loss is related just to pills of controlled substances being illegally distributed. $245 million have been seized, whether that's through cash or other assets, from individuals who are being investigated by the government. Those are criminal investigations. That's money that's being seized by, in connection with those criminal investigations. In connection with criminal enforcement, there have been 324 defendants charged and 96 medical professionals charged. So, the remaining people could be, just individual actors, owners of companies, but you can see that's still a significant number, almost a third of the defendants who have been charged are healthcare providers. Healthcare fraud is a hot topic for the government. It's a big area of spending and it's a big area of enforcement. For civil enforcement, $48.6 million has been in civil settlements and charges, and there's been 126 defendants so far, and that's covered 50 different federal districts. Okay, so unsurprisingly, enforcement efforts are continuing to accelerate post-COVID. We did see, a little bit of a slowdown, during COVID, but that has, dramatically ramped back up and stayed very active. Settlements and judgments from civil cases involving fraud and False Claims Act investigations against the government exceeded $2.9 billion in fiscal year 2024. Of that amount, more than $1.6 billion was attributable to healthcare-related cases and matters. And you can see in the chart that we have on the screen, those are the total civil fraud recoveries. And we have a little timeline for you. If you can see 2019, it was $3.1 billion. 2020, there's a little dip there. That was when, obviously COVID occurred. We all remember that. $2.2 billion. But then in 2021, the subsequent year, $5.6 billion in civil fraud recovery. So, we amped right back up in 2021. 2022, again, $2.2 billion. 2023 increasing to 2.68, and then last year with the 2.9 billion. In 2024, there were 979, which is a record number of whistleblower cases that were filed. This is a significant increase over the 757 TTM cases that were filed by whistleblowers in 2023. We'll talk more about the False Claims Act and whistleblowers, but many False Claims Act cases are brought via whistleblowers, and we refer to those as KETOM cases. In the first 2 months of 2025, the government settled 2 False Claims Act cases already, totaling $878 million. So significant money has already been recovered so far. That was just in the first 2 months of this year. Now I'm just going to take you through a few cases to give you some real life examples of enforcement action happening. Many of these cases are in Texas. Some of them are in different parts of the country, just to give you a smattering of examples. The first one we have is out of Houston. In this case specifically, the husband and wife owned a home health agency. Both pleaded guilty to conspiracy to commit healthcare fraud. They were sentenced to prison. The husband specifically was sentenced to 12 months in prison. The wife was sentenced to 48 months in prison. The wife was alleged to have obtained patient referrals by paying kickbacks to marketers and patients and bribing physicians to authorize medically unnecessary home health services for the agency's patients. She also admitted to billing Medicare for over $8 million in fraudulent claims for home health services. Her husband also admitted that he had filed a fraudulent cost report to Medicare and attempted to disguise the kickback payments that his wife made as legitimate business expenses. So again, kickbacks are a hot issue. A number of these cases are going to involve kickbacks. It's not the only thing that we have going on, but a number of these cases are kickbacks. Those are very interesting cases to the government, very important to consider your referrals and your marketing contracts. Out in McAllen, down in South Texas, we have a medical director of a large hospice and home health chain who was sentenced for his role in a scheme that involved the submission of over $150 million in false or fraudulent claims to Medicare for hospice and home health services. According to the government's allegations, the company falsely told patients that they had less than 6 months to live. They also sent chaplains to the patients based on false pretenses that they were near death. The company also made payments to their medical directors. Those fees were contingent upon an agreement to certify an unqualified patients for hospice. Clearly problematic. And the defendant also received luxury trips, bottle service at exclusive nightclubs, and other perks in exchange for his certification of unnecessary hospice patients. Another case out of Houston and McAllen again, actually. The first case out of Houston. The owner of a home health agency was sentenced to 57 months in prison after being convicted of conspiracy to commit healthcare fraud. This defendant was alleged to have caused the agency to bill Medicare for home health services that were not medically necessary and not provided, and paid medical clinics for fraudulent home health certifications and unlawfully paid for patient referral. So a mix here. We've got, medical necessity coverage issue, and we also have a kickback issue. Down in McAllen again, owner of a home health agency was sentenced to 45 months in prison after being convicted of conspiracy to commit healthcare fraud. The defendant was alleged to have submitted false and fraudulent claims to Medicare for reimbursement of home health services that were not provided, that a physician had not authorized and or were not medically necessary. He also paid illegal kickbacks in exchange for patient information, including Medicare patient numbers. He and or his co-conspirators would then use that fraudulently obtained Medicare information to submit claims to Medicare in order to receive reimbursement. So they're buying Medicare data and submitting claims based on that data that they were purchasing. Okay, some cases from other parts of the country for you. In 2024, last year, out of Michigan, there was an individual that was sentenced to 9 years in prison for orchestrating nearly a $2.8 million healthcare fraud and wire conspiracy and engaging in money laundering, aggravated identity theft, and witness tampering. According to the government, despite being excluded from Medicare, which we all know means you cannot participate directly or indirectly in the program, this individual still somehow managed to purchase a home health company using the names and signatures and personal identifying information of others to conceal his ownership in the company. So he used a straw man, essentially, to purchase this company. In a 2-month period, the owner and his co-conspirators billed and were paid nearly $2.8 million by Medicare for services that were never rendered. The owner then transferred these funds through bank accounts belonging to shell corporations, and eventually those funds were sent overseas. Another case from January 2024 in Arizona. Here specifically, a home health care agency that was operating in Arizona along with 8 other states agreed to pay nearly $10 million to resolve allegations that had violated the False Claims Act by submitting false claims to the healthcare program administered by the Department of Labor for the benefit of the Department of Energy employees and contractors with occupational illnesses. According to the government's allegations, this company between 2017 and 2021 falsely billed the federal government for in-home nursing and personal care when its employees were not physically present in patients' homes. It also paid kickbacks in the form of cash payments up to $5,000 for patient referrals via its Friends and Family program and in-kind payments for food, internet, travel, and other expenses made to patients and their families. Very, very problematic conduct. This case actually originated from claims of a former employee who was employed as the corporate administrator and director of human resources and administration and management. So clearly a whistleblower allegation here. Couple more for you out of the Northern District of Illinois. An owner, there's two separate owners here. So owner number one owned several home health agencies and allegedly maintained relationships with marketers and signed sham contracts with patient marketers on behalf of companies, while a second owner alleged to have facilitated kickback payments to marketers by writing checks to himself and other agency employees who would then convert the checks to cash that was used to pay kickbacks to marketers. The first owner caused fraudulent claims to be submitted to Medicare for home health services that falsely represented that she, as a registered nurse, performed assessments of patients on dates when she was out of the country. The government loves to pull that data. They love to pull data that shows that you were out of the country, you have passports in another country, here's your flight information, yet somehow you're providing services in the Northern District of Illinois at the same time. It's impossible. It was also the practice of the owner's companies to admit, discharge, and recertify patients repeatedly, regardless of their medical conditions and whether or not those were reasonable and necessary. Out of the Southern District of Florida, a marketer pleaded guilty to one count of conspiracy to commit healthcare fraud. According to the court documents, the marketer and his co-conspirators paid kickbacks to the Medicare beneficiaries to recruit them for referrals to home health agencies. The marketer also coached the Medicare beneficiaries who did not need home health services on what to say to obtain home health prescriptions from doctors. In exchange for referring these beneficiaries, the marketer solicited and received kickbacks and bribes from home health agencies. These were attempted to be disguised by them routing them through shell companies. Out of the Northern District of Illinois, a healthcare consulting company, which was based in Pakistan, has been engaged to handle the Medicare billing and EHR maintenance for 20 home health agencies in Illinois, Indiana, Nevada, and Texas. While working at the company, one individual allegedly caused the agencies to submit fraudulent claims to Medicare for home health services, which resulted in over $40 million in payments for services that were never rendered. All right, two more for you. First one's out of the Central District of California. The administrator of a Southern California hospice was sentenced up to 30 months in prison for his role in a multi-million-dollar hospice fraud scheme. As a part of this guilty plea, the defendant admitted that while acting as the administrator for the hospice, which was located in Downey, California, he and others paid illegal kickbacks to patient recruiters for the referral of hospice beneficiaries to the hospice agency. In addition, when the clinical staff of the hospice determined that the beneficiary is no longer qualified to receive hospice services, or perhaps never qualified to receive hospice services, he overruled those determinations and nonetheless caused the beneficiaries to be put on hospice services, even when he had medical professionals telling them that they did not meet the terminally ill requirements of 6 months or less to live. Southern District of Texas, last example for you today. The operations manager of a chain of hospice and home health agencies throughout the Rio Grande Valley was sentenced to 27 months in prison and ordered to pay $4.7 million in restitution for his role in a conspiracy to falsely convince thousands of patients with long-term incurable diseases that they had less than 6 months to live in order to enroll these patients in hospice care. Otherwise, these patients were unqualified. And this obviously increased revenue to the company because they have more patients on their census. At trial, his co-defendants, witnesses at a trial of his co-defendants, witnesses testified that the vast majority of hospice and home health patients at the group of agencies did not actually qualify for the services they received. The government alleged that physicians were bribed with illegal kickbacks under the pretense of medical directorship. Physicians falsely certified unqualified patients for services, and employees were instructed to falsify medical records, making non-terminal patients appear to be terminally ill and declining. So where do these fraud investigations originate from? There's a lot of different ways that they could originate, but one of the ways they originate is through audits, actually. CMS requires that UPICs store the most recent 36 months worth of data for home health and hospice agency claims. It uses that data along with other data sources to identify outliers and potential audit targets. One thing that the government is very good at is collecting data, and they use that data to conduct audits and investigations, and that is a major source of where many of these cases originate from. So the UPIC specifically, the Unified Program Integrity Contractors, who are contractors that work on behalf of CMS, so this is Medicare specifically, use data mining to go through all that data and see who stands out from their peers, who is billing for tons of services, or who is billing for services that are being ordered by one specific doctor. Is one specific doctor sending a ton of patients to one specific home health agency? They'll look at the volume of business, the percentage of Medicare and Medicaid patients, if there have been any prior investigations, if there have been other audits in the past, what are those error rates like? That's why it's always important to appeal your audit results. They'll also see if there's a history of this provider returning overpayments. And again, if a provider is being audited, do they appeal those results and are they successful? In addition to data mining, other ways that you can come up for an investigation are through complaints. These can be complaints that are anonymously left with OIG, for example, by a beneficiary or another physician, a competing home health or hospice company, or prior disgruntled prior disgruntled employees or current disgruntled employees. There can be referrals, obviously, from the UPIC, like I mentioned previously. Other contractors as well can make referrals. So if you have a SMRC audit or a MAC audit, like a RAC audit review, the state MAFUCUs, the Medicaid Fraud Control Units, can also do their own investigations and can refer those. There are lots of different ways that these can come up. The OIG and the GAO also regularly issue reports that address areas of concern that essentially identify target areas that need to be looked at. These reports really kind of give you an indication of what's going to be a hot item for the government. And, many times those include hospice and or home health agencies and their services that are provided. State licensing boards can also make referrals. So the medical board, if they're looking into, for example, one of your medical directors, they can make a referral and say, we think this doctor was ordering tons of hospice services that were not medically reasonable and necessary, and that can result in an investigation of the hospice, for example. I do want to point out that for the UPIC specifically, there is language in the Medicare Program Integrity Manual that the UPICs they absolutely will refer cases of potential fraud to the OIG for investigation. We actively see that. I see where the UPIC starts an investigation, you never hear anything back, and typically that's because they're trying to refer it to the OIG for more investigation. If a non-UPIC contractor identifies fraud or abuse, these contractors have still been directed to refer cases involving potential fraud and abuse to the UPICs. There's language specifically in the PIM again that says contractors shall analyze provider compliance with Medicare coverage and coding rules and take appropriate corrective action when providers are found to be non-compliant. For repeated infractions or infractions showing potential fraud or a pattern of abuse, more severe administrative actions shall be initiated. At any time, evidence of fraud shall result in a referral to the UPICs for development, and then obviously the UPICs can refer it to the OIG or to the DOJ from there. In addition, your MACs, your Medicare Administrative Contractors, are required to refer potential fraud, waste, or abuse situations to the responsible UPIC, who can then obviously refer it on, forward complaints alleging fraud through the screening staff to the UPIC, and forward to the UPIC detailed documentation of telephone or personal contacts involving fraud issues discussed with providers, supplier providers, supplier staff, and retain such information in individual provider or supplier files. And I have seen this before. For example, we've had cases where the case has remained with a UPIC, and we've subsequently received a FOIA file that has information. It's got a whole investigative history where OIG has looked into it, they've declined it, they sent it back down to the UPIC, but this absolutely does happen all of the time. So if you get a request from a UPIC, that does not mean that this is necessarily just an administrative matter. Many times it does. We've got this little chart on the screen for you. So primarily, if you get a letter from a UPIC, typically they're going to be looking to see whether the documentation met the requirements for coverage and payment, and you'll get a letter a couple months later identifying an alleged overpayment. You can take that through the administrative appeals process. That is the typical course of action. We see that very often. We handle tons of those cases. They can also initiate a payment suspension action against the provider. They can do that in conjunction with the audit. They can revoke you. They can revoke your provider or supplier's Medicare billing privileges. We are seeing a ton of activity in that specific area. That's not our topic for today, but just an FYI. If you get audit results back, you need to appeal those, because we are seeing very heavy enforcement action in connection with revocations based on prior audit history. The least likely, but still possible and still absolutely does happen, is that the UPIC does the initial review and refers that case to law enforcement for civil or criminal prosecution. So in terms of you getting a UPIC records request level, do you need to immediately panic and think you're being referred to the Department of Justice or the OIG for investigation? No, not necessarily, but it's very important that you take these audits very seriously, because that is absolutely a possibility. Okay, so turning to the False Claims Act. Just some historical background for you today. The False Claims Act actually is sometimes referred to as Lincoln's Law. It was first passed in 1863 in response to war profiteering during the Civil War. Among its provisions were measures intended to encourage the disclosure of fraud by private persons through the filing of a quitom suit. The term quitom is actually taken from a Latin phrase, which means he who brings a case on behalf of our Lord the King as well for himself. We commonly call these whistleblower complaints, whistleblower cases, because under the provisions of the statute, a private person who we refer to in these cases as a relator can bring a False Claims Act lawsuit on behalf of the United States and then possibly share in any recovery made by the government. So in these cases specifically, the claims at issue, the false claims, are every single CPT code or HCPCS code that is getting submitted to the government for reimbursement. Those are the claims that are allegedly fraudulent. And any private person, many times a current or former employee who typically has tried to notify the company about their concerns, and those concerns have fallen on deaf ears, will then go out and file a private complaint under the False Claims Act. And if the government intervenes, or if it does not, and the case proceeds, the relator, if there's ultimately a judgment or a settlement in those cases, the relator can get 15 to 20% of the total settlement amount in that case. And most of these cases, settle for millions of dollars, a significant amount of money that the relator gets in these cases that if they file them under the False Claims Act. So there is certainly an incentive for individuals to file those cases. What are the provisions of the False Claims Act? Simply put, the FCA imposes civil monetary penalties and damages on any person who knowingly submits or causes to be submitted a false claim to the government for payment. The term knowingly does not merely mean actual knowledge. It also includes reckless disregard or deliberate ignorance. What does that mean? That means you can't just put your fingers in your ear, stick your head in the sand, and pretend like you don't know the rules. It also means that you can't just ignore a problem or say, well, I'm not the one that's really involved in the submission of it, and back away from it and escape liability. That's not a way to avoid False Claims Act liability. You also do not have to actually know that what you are doing is a violation of the False Claims Act to be found liable under the False Claims Act. The statute of limitations for False Claims Act cases is typically a 6-year statute of limitations that can be told in certain circumstances, which means, you know, the government, if they initiate a case and it's taking a long time to resolve it, they can potentially seek a tolling agreement where we agree that we'll still allow you to pursue these claims even though 6 years has passed. And they can also actually go up to 10 years total from when the government knew or reasonably should have known that the violation occurred. Typically, when we're seeing these cases, they're using that 6-year timeline, but it's certainly within their abilities to do the full 10-year time period. And I've actually seen some recent requests for essentially what we would call discovery and information that's seeking up to 10 years of data. So they certainly are able to use that authority, and they do. What are the damages and penalties under the False Claims Act? Any person who is found to have violated the statute is liable for both civil penalties and treble damages. So treble damages means that if you are alleged to have defrauded the government for $1 million, they can collect $3 million. That's 3 times the single damages. In addition, there are penalties that can be attached per false claim. And remember, every single CPT code, HCPC code, that is a claim. So for every single claim involved in the time period that's being looked at, there can be a penalty of $14,308 to a maximum of $28,619. So between the treble damages and the penalties, the alleged potential damages in these cases can balloon very, very quickly. It can become very expensive. You know, maybe not all of that would actually be recoverable, but it's certainly a number that the government will put on the table as something they are going to seek if this case goes to litigation. So I mentioned discovery in these cases. How does the government get this discovery to actually, you know, find evidence in support of the allegations that are potentially filed by a whistleblower? Typically, we see federal prosecutors relying on something that's called a civil investigative demand. We refer to that as a CID. They use that in False Claims Act matters, and ones that they initiate themselves and ones that are initiated by whistleblowers. The civil investigative demands can request all sorts of different information. They can request documents, medical records, contracts, financial information, ownership information of the company, contact information for all of the employees. They can also request something called an interrogatory, which is essentially a question that the government asks for you to respond to and prepare an answer to. So they can, you know, ask for that, the documents, the questions, and they can also compel testimony and request that you testify and answer questions. Those can be formal or informal, meaning there's a court reporter if it's formal or not. Can responses to a civil investigative demand be used in a criminal prosecution that's parallel? Yes, absolutely it can. The Supreme Court has held that it is permissible for the government to conduct parallel civil and criminal cases as long as it does not act in bad faith. That's why a lot of times when we resolve these cases through a settlement, we try to talk to the criminal side of the house to confirm that they don't have a parallel investigation ongoing, because we don't want to settle the civil matter if we're then going to be, you know, dealing with a criminal matter afterwards. As I stated previously, yes, you can be compelled to provide oral testimony in connection with CIDs. It is certainly permissible if the government requests it. If that happens, it is essential that you work with a healthcare attorney to assess whether you have any criminal exposure before you give any oral testimony to the government, because you may need to invoke, you know, your rights under the Fifth Amendment. A question that always comes up if we're invoking our Fifth Amendment rights to not self-incriminate ourselves is always, is there going to be an adverse inference if I don't testify? the decision to not exercise your Fifth Amendment rights is not a decision that you can take lightly. It's important to keep in mind that if you do assert the Fifth Amendment, the government could seek to have the court issue an adverse inference instruction if the case were to ever proceed to litigation. So certainly possible that instruction could be issued. So absolutely, this is something that you need to talk through with counsel. You have to review the specific facts in your case and then make a decision about how to proceed if testimony is requested. I will say that sometimes you're able to push back on the request for testimony by just responding to interrogatories and providing documents, but that's not always possible. It depends on the specific case and it depends on the specific prosecutors. Okay, federal anti-kickback statute. This was first enacted in 1972. Under this statute, it is a crime, it is a criminal statute, to knowingly and willfully solicit, receive, offer, or pay any remuneration in return for referring or arranging for services payable by any federal or state healthcare program, or purchasing, leasing, ordering, or arranging for any goods, facilities, or services that may be paid for in whole or in part by any federal or state healthcare program. This was the Affordable Care Act had a modification here for the anti-kickback statute. And under the ACA, a person need not have actual knowledge of this section of the anti-kickback statute or specific intent to commit a violation of the anti-kickback statute. This change is a big deal. It effectively lessens the requirements needed for the government to bring a criminal case under the anti-kickback statute. They don't have to show that you specifically intended to violate the anti-kickback statute when you entered into a marketing agreement, for example, to refer patients and get paid for those referrals. You also don't need to know that the anti-kickback statute exists to be found that you violated it. And it's also important to note that the anti-kickback statute isn't just going to apply to situations where money was paid, and it's not just money, right? It's that word remuneration. It means anything of value. So concert tickets, Kentucky Derby tickets, all sorts of things of value, free rent at your facility to allow somebody to use that space for free. Even just making the offer, that can be considered a violation of the anti-kickback statute. So it doesn't have to necessarily be followed through. There are increased penalties and imprisonment for kickback violations. The criminal penalties for acts involving the federal health care programs are now $25,000 to $100,000. The maximum sentences for felonies that involve federal health care program fraud and abuse can be from 5 years to up to 10 years. So significant penalties and possible jail time for violations of the anti-kickback statute. The federal anti-kickback statute and the False Claims Act for a long time were essentially totally separate tools that were utilized by the government to investigate and prosecute healthcare fraud. False Claims Act is primarily used in civil enforcement matters. Anti-kickback statute typically used in criminal matters. Over the past 20 years, the enforcement landscape has changed. Starting in the early 1990s, whistleblowers started asserting violations of the False Claims Act in cases that would typically be pursued as a criminal violation of the anti-kickback statute. These cases often involved fact patterns where a party was alleged to have violated the anti-kickback statute, and in the process of violating the anti-kickback statute, billed for services that were actually worthless and made a false express and or implied certification to the Medicare or Medicaid program. In 2010, when the Affordable Care Act was being passed, this obviated the need to bootstrap violations of the anti-kickback statute into violations of the False Claims Act. So now, under the ACA, a claim submitted in violation of the federal anti-kickback statute automatically constitutes a false claim for purposes of the False Claims Act. So a lot of times now, we see these cases automatically together. If there's a violation of the anti-kickback statute, there is typically always going to be also a violation of the False Claims Act. The anti-kickback statute does have some safe harbors where there is potential coverage for certain conduct, but you have to meet the safe harbor requirements. There are 11 safe harbors that were passed. There have been additions over the years. There are now 38 total regulatory safe harbors. These are voluntary. They are not mandatory. And while a given arrangement is not necessarily a violation of the anti-kickback statute, if one or more elements of a safe harbor have not been met, then a provider is effectively precluded from relying on that safe harbor as an absolute defense. So it's very important that if you are trying to rely on a safe harbor, and I'm going to go through just a couple of them, some of the more common ones, but it's important that you meet every element to make sure you're covered and you're not in violation of the anti-kickback statute. So the first one I'm going to talk about is the personal services and management contracts safe harbor. This is particularly for 1099, your 1099 employees, your marketing employees, most likely. This specific safe harbor has very specific items that need to be met. For example, an agreement has to be in writing and signed by the parties. The agreement must cover all of the services that the agent provides to the principal for the term of the contract and specify the services to be provided by the agent. The agreement must be for at least a year. The methodology for determining the compensation must be set in advance, be consistent with fair market value in an arm's length transaction, and cannot be determined in a manner that takes into account the value or volume of any referrals of business generated between the parties for which payment is made by Medicare, Medicaid, and other federal health care programs. A couple other provisions as well, but those are some of the main ones. And that volume or value and fair market value terms, those are critically important. You need to make sure that if you have marketers, for example, that are 1099 employees, you have had a healthcare attorney, not somebody who did your divorce. You want to have a healthcare attorney review those contracts and make sure they meet the provisions of the safe harbor to protect your agency from kickback and false claims act liability. Next slide. There's also an employment safe harbor. So these are for your regular, everyday employees. Employees, though, need to meet the IRS definition of an employee. These are bona fide employees in the eyes of the IRS. If you do meet these specific provisions of the IRS definition, then you have a little bit more leeway in how you can pay people. But it's very, very important that you do an analysis and make sure that you're not just disguising a contractor. Some of the specific items that are looked at in these cases are the hiring party's right to control the manner and means by which the product, meaning whatever the purpose of the person's job is to be accomplished, the level of skill that's required, the location of the work, the duration of the relationship between the parties, whether the hiring party has a right to assign additional projects to the hired party, the method of payment, whether the work is a regular part of the business of the hiring party, the provision of employee benefits. So, for example, do they get vacation? Do they get sick time? Do they have a 401k? Those are all things that are being looked at. Do they work regular hours? Do they work, 40 hours a week? And the tax treatment of the hired party. So those are just a few elements. There's others as well, but a few that need to be looked at, especially if you are going to pay bonuses, things like that. What does the Office of the Inspector General say about fair market value? In 2015, the OIG issued a fraud alert that specifically discussed physician compensation arrangements. And this really served as a warning to physicians and organizations about how people are getting paid. Specifically, the OIG said that it reached 12 settlements with individual physicians who entered into questionable medical directorship and other staff arrangements. The OIG alleged that the compensation paid to these physicians under the medical directorship arrangements constituted improper remuneration of the anti-kickback statute for a number of reasons, including that the payments took into account the physician's volume or value of referrals and did not reflect fair market value for the services that were to be performed. So the OIG also alleged that some of the 12 physicians had entered into arrangements under which an affiliated healthcare entity paid the salaries of the physician's front office staff. So, additional things being added in as additional incentives. So it's really important that if you're utilizing medical directors, for example, in this example, that they are accounting for the time that they are working and that there's a log of that so that you can show what you're paying for. And you need to make sure that the hourly amount that you're paying these individuals is in fact fair market value for the work that's being performed. Are they, coming in and doing a chart review? Are they being paid appropriately for that hourly work that's being done? A couple recent kickback areas, some examples of problematic conduct, business arrangements with individuals who have the ability to refer business to your practice. That is a very, very common area. Who are you getting into business with, and do they have the potential to make referrals to your home health or hospice agency? Lease arrangements, like I said, you can't just give somebody free office space in your agency. That would be considered a kickback. Working as a medical director for a home hospice or home health agency, that is a very hot item. These are people who can refer patients to your home health or hospice agency. You need to make sure that if you have medical directors, that those are being papered appropriately and that they're keeping logs of the work that's being done for that compensation. Having people bring in lunch and other goodies to the staff is still very common. It can be problematic. Is the government going to pursue a case over, a lunch once or twice a year? Probably not, but there's no de minimis amount under the anti-kickback statute. So it's important to keep that in mind. Participating in sham arrangements where your agency is giving loans, research grants, or speaking fees to any individual from whom you receive referrals. Giving cash or other items of value to a patient, that should be pretty obvious, but we certainly still see it in cases that come up. Again, it's not just cash or gifts, it's any sort of remuneration, anything of value can be considered a violation. So we need to keep that in mind. Something we hear commonly from clients is, well, this is what everybody else is doing. Just because everybody else is doing it and hasn't gotten in trouble yet does not make it permissible. Some other common statutes that are cited in False Claims Act cases, just going to take you through a couple here. Standard healthcare fraud. Under this statute, it is unlawful for any person to knowingly and willfully execute or attempt to execute a scheme to defraud any healthcare benefit program or obtain by false pretenses any money or property owned or under control of a healthcare benefit program. It's important to keep in mind that the healthcare fraud statute covers government and private payer healthcare programs. Also, with the anti-kickback statute, the government does not have to show that the defendant had actual knowledge or specific intent to violate the statute in order to prove its case. Obstruction of a federal audit is another statute that we see commonly in these types of cases. Under this statute, whoever, with the intent to deceive or defraud the United States, endeavors to influence, obstruct, or impede a federal auditor in the performance of official duties relating to a person receiving in excess of $100,000 directly or indirectly from the United States in any one-year period under a contract or subcontract can be found in violation. Under this statute, a federal auditor means that any person employed on a full or part-time contractual basis to perform an audit or quality assurance inspection on behalf of the United States. You cannot, keep those individuals from doing their jobs. There was a period of time where we saw identity theft being included on these cases, which you can kind of see, because if we're utilizing a Medicare beneficiary's information to carry out a fraud, you're using healthcare, you're using somebody's HIC number to file a claim for services that you don't actually meet the requirements for coverage and payment for. We saw the government including aggravated identity theft as an additional way to increase the penalties on these cases. I will say that in 2023, the Supreme Court came out in a case called Dubin versus United States, which essentially said that the aggravated identity theft statute is violated when the defendant's misuse of another person's means of identification is at the crux of what makes the underlying offense criminal, rather than merely an ancillary feature of a billing method. Being at the crux of criminality requires more than just a causal relationship, such as the facilitation or the offense being a built-in cause for the success of that fraud. So they can no longer just tag that on a False Claims Act investigation. The aggravated identity theft has to be a crucial component of the fraud that's been carried out. A couple more. So False Claims 18 U.S.C. 287, that's the Criminal False Claims Act statute. Whoever makes or presents to any person or officer in the civil, military, or naval service of the United States any claim upon or against the U.S. or any department, agency thereof, knowing such claim to be false, fictitious, or fraudulent, shall be imprisoned for not more than 5 years. There's also a statute on false statements involving healthcare programs and on statements or entries generally. Under that one specifically, where there's no specific statute that can be used to prosecute a false statement, the United States Attorney can rely on the statements or entries generally to prosecute defendants. It's really a general catch-all provision that is unlawful for a person to knowingly and willfully falsify, conceal, or cover up material facts, make any material false, fictitious, or fraudulent statements or representations, and make or use any false writing or document knowing the same to contain any materially false, fictitious, or fraudulent statement or entry. So there's other ways for them to prosecute these types of actions besides just the False Claims Act and the Anti-Kickback statute. Next slide. So this is notable and something that we're seeing. In 2022, the Attorney General, Lisa Monaco, issued an update to some prior guidance that was issued. And essentially, the DOJ is stating that its priority is to hold accountable individuals who commit and profit from corporate criminal crime. Corporations can best deter misconduct if they make clear that all individuals who engage in or contribute to criminal misconduct will be held personally accountable. In assessing a compliance program, prosecutors should consider whether the corporation's compensation agreements, arrangements, packages incorporate elements such as compensation clawback provisions that enable penalties to be levied against current or former employees, executives, directors, whose direct supervisory actions or omissions contributed to criminal conduct. We are seeing an increase in personal liability for the individuals at corporations. So you cannot just expect to have a False Claims Act case or an anti-kickback case filed against your home health agency or your hospice agency. The government wants to hold the individuals accountable. They recognize that there are individuals that are making decisions behind these corporations. So you can't expect just to avoid personal liability by hiding behind an organization settlement with the DOJ or the OIG. It's very important that you have personal protections as well. And it's very common that, the government will file a case against a corporation and the owners individually. They want to hold the individuals accountable too. Okay, so a few non-kickback problems that have been identified in recent cases that we've seen. I'll go through these fairly quickly. I know we're starting to run out of time. Failure to properly document support for medical necessity. This is always a big issue. Documentation is the king. You have to document the services that you're providing. It needs to meet the requirements for coverage and payment that are laid out by for example, the applicable LCD for your jurisdiction. You need to make sure that you not only have good notes for the dates of service where a patient is seen that shows the medical necessity for the services on every date of service. You also need to make sure that you've got the certification documentation, you've got your orders, you've got recertifications, your plans of care, everything is signed, it's dated appropriately, it's being dated before you're billing for the services. You know, the worst thing to see is a document that is dated the day that, you know, an audit request comes in or a civil investigative demand comes in and somebody's sitting back there signing a bunch of documents. That is not proper. These should all be signed and dated as soon as possible. They should absolutely be signed before services are billed. Failure to sign treatment notes goes along with what I was just saying. This happens probably more in physician practices than in home health and hospice agencies. But many times we'll see a progress note and none of them are signed. And they'll all get signed and closed out the day that, you know, an audit request comes in, for example. And sometimes I've been told that providers don't do that because they want to go back and be able to make changes. It's inappropriate. Your documentation, you should finish your documentation as close in time to the date of service that those services were provided, and you need to finalize and sign every treatment note. If you need to go back and make a subsequent change, that can be done through an addendum that is signed and dated the day of the addendum. Missing medical treatment plans or consent forms, very important information that you need to have. This is very, very important for home health. It's critically important for hospice. You need to have that documentation. Many times that's a separate document that needs to get scanned into your EMR system. Please make sure you're scanning in that documentation. You're linking it to the patient's record so that it's readily available if that documentation is requested. I see many times in fraud investigations and in audit requests where providers are having to pull from a ton of different places to get documentation because the documentation isn't linked, or documentation gets left out because it's not linked to the patient's chart. Please take the time to do it at the outset so that that information is there. Allowing unlicensed staff to provide care. This comes up a lot more than you would think. This is a really quick way to get in trouble, allowing non-licensed individuals to provide medical care that can only be provided by licensed personnel. Some instances, maybe the agency doesn't know, but a lot of times they do. For example, in January 2024, an individual in Laredo worked for 2 years, 2017 to 2019, in multiple hospitals and home health companies and was impersonating a nurse. So it does happen when you don't know, but that's where your background checks need to come in. You need to make sure you're doing that so that you don't find yourself in this situation. Billing for services not rendered. Obviously, that's a big one. We don't want to submit bills for services that weren't actually provided. This can just be because you're not good at documenting your services. That can come up as an issue, but it can also be indicative of fraud and, you know, criminal conduct. Misrepresenting the services that you're providing. You know, if you're saying that a person, for example, needs a service, like if they need skilled nursing, but then they're also getting physical therapy, or vice versa. You know, if you have a home health patient that needs physical therapy, but then everybody gets skilled nursing too, we need to make sure that we are representing the services that a patient needs and that we're billing for the services that they need, and we're not misrepresenting that they need additional services that may not be medically necessary. Next slide. Okay, so a few final points as we wrap up today, and we'll see if y'all have any questions or anything. But it's very important, we've talked a lot about anti-kickback statute. Make sure you're looking at your contracts, your leases, your payment arrangements with your physicians and other providers in the community. Make sure those arrangements meet the anti-kickback safe harbors. If you have not had a healthcare attorney review those, now is a great time to do that. Make sure those contracts are compliant. Review your ownership structure to identify any potential anti-kickback or START issues. Do you have any investors who can be a potential source of a referral or who can induce referrals? That could be problematic conduct. Review your policies, procedures, and training. For your marketing staff in particular, your community liaison staff, these are people who are sending in referrals to your company. You need to make sure that they understand what the law says so that you remain compliant. You'll be much better served if your marketing staff are true bona fide employees, like I discussed earlier. And if they are, you need to make sure you're training them like they're a full-time employee. If you do not have a compliance plan in place, you need to get one in place as soon as possible. You should have one. In fact, in Texas, if you're a Medicaid provider, you've agreed that you have a compliance plan in place. So if you have signed that contract and you don't have one in place, then you've made a misrepresentation to the government. Healthcare providers and suppliers are under intense pressure to get compliance plans in place. They have a lot of scrutiny from law enforcement. It is essential that you have a compliance officer that is knowledgeable about all the applicable laws and regulations and that can help address concerns within the company. If there are issues that come up, if you are a compliance officer, for example, and you are notifying your CEO, for example, about problematic conduct, you have a few different things that you can do. If you can notify the company about the conduct, hopefully they will do the right thing. What if they don't? We get asked that a lot. Should you continue to work for the company despite the fact that you know that wrongdoing is taking place? No, you absolutely should not. Can you just email the CEO, for example, and say you disagree with what they're doing and continue working for the company? No, you cannot do that either. That doesn't absolve you of liability. Can you resign from your position? Yes. Can you resign from your position and file a complaint with the affected payers? Yes, you absolutely can do that. If you are aware that your organization is engaged in wrongdoing, do you have an obligation to turn them in? Under the U.S. Code, there's a provision called a misprision of a felony. And this language specifically says, whoever having knowledge of the actual commission of a felony by a court of the United States conceals and does not as soon as possible make known the same to some judge or other person in the civil or military authority of the United States shall be fined under this title or imprisoned not more than 3 years or both. So if you have knowledge of the actual commission of a felony, I would recommend that you are reporting this information to the OIG or to some other enforcement agency. Next slide. Final considerations. If you are investigated, if you receive a CID, we recommend that you retain counsel. Something we tell our clients is everything that you say to the government can be used as evidence. Everything your attorney says is an argument. First thing you want to always do is determine the focus of an investigation. Is it administrative? Is it civil? Is it criminal? That's going to be something that your attorney is going to ask first thing. Conduct internal investigations. If you are not conducting regular internal auditing and monitoring, you should absolutely be doing that. If you receive notice of an investigation, conduct your own review. See if you can turn the lights on and figure out what's going on. That will help you determine the extent of liability. Make sure you're retaining documents. Don't make an investigation worse by destroying documents. That is absolutely a no-no. Do not antagonize your employees. Guard against possible allegations of obstruction of justice. Work with the government to aggressively resolve the case and work towards a global resolution of the claims. Don't just solve your civil allegations and leave other potential criminal or administrative claims out in the open. That could bite you later on. So work on a global resolution. And that is all I have for y'all today. I hope this information was helpful. Gio, do we have any questions?
No, I don't think so. Yeah, so I guess we can conclude it here. So that concludes today's webinar. Thank you for joining us, and thank you to our speaker, Ashley Morgan. Everyone from today's webinar will receive a copy of the presentation tomorrow via email. And if you have any further questions about today's discussion or another healthcare law issue, please feel free to reach out to Ashley or directly to Lowell Parker. Have a good Wednesday and take care.